Hi, I'm Christopher Dumm, wealth planning attorney. This encompasses elder law, estate planning, but I like the term wealth planning because in our office we not only concentrate on our client now, but also if they became disabled, and then of course if they passed away. One of the philosophies of our law firm is that a good wealth planning attorney-client relationship is about relationship and not a transaction. So many times people will ask me, should I have a will? Should I have a trust? And the answer many times is, it really doesn't matter because both will fail. And the reason I say that is because those are documents. What we think clients are really asking for are results, not documents. And so that's where we start first. So one of the first questions we'll ask is, tell me about your family, because we're not experts on that. You are the closest thing we have to being an expert on your family. I'll make you a promise that if you educate me as to everything I need to know about you and your family, I will educate you as to everything you need to know about wealth planning strategies. So you have many options in wealth planning. 75% of Americans have chosen to do nothing. Well, that's not a really good option. One option in wealth planning is to use a will. A will is a small stack of paper which tells the probate court what to do with your stuff that is running through probate. However, a will does not avoid probate, and a will does not do any disability planning for you or for your loved ones. Probate is basically a lawsuit that you file against yourself with your own money for the protection of your creditors. Probate was set up in England back in the Middle Ages to protect the number one creditor in England, the king. You've probably seen advertisements in the paper or notices that say, this person passed away, this attorney is taking care of their financial affairs, and if they owe you money, please send us a bill. The person that passed away paid for that advertisement to plead with their creditors to please send them a last bill. One of the complaints of probate is that it takes a long time. Part of the time delay is to give time for creditors to send in their final bill. Every client I've ever met with has told me they wanted to avoid probate. So when they avoid probate, they are decreasing the chance that the will actually control anything, because the only place on this planet where a will can be enforced is the probate court. Avoiding probate is not wealth planning. It is merely probate avoidance. If you want to avoid probate and do wealth planning, we may want to look at a revocable living trust. A revocable living trust is like a little red wagon. You probably had a little red wagon when you grew up. And what did you put in that wagon? All your stuff. And who pulled the wagon around? Well, you did. And so it didn't matter if you were holding your stuff, if your stuff was in your pocket, or if it was in a little red wagon. You were in control and you were receiving the benefit of those items. One of the reasons people use revocable living trust to accomplish their wealth planning goals is because it allows them to control things while they're alive, control what happens if they became mentally incapacitated, and also to control who gets what, when they get it, the way they get it, and how they get it when they pass away. You have lots of options when creating a revocable living trust. My wife and I each had revocable living trusts, and a few years ago, my wife passed away. When she did, all of the stuff that was in her wagon, we put a lid over that wagon, we locked it, and we gave the key and the instruction manual for that trust to the next trustee. Guess who that was? If you guessed me, you're exactly correct. So, although I don't own the assets that are in my wife's trust, I'm in control of it, and my daughters and I receive the benefit of it, and our creditors can't get to it. So why do I say that creditors and predators can't get to what is in my wife's trust? Well, the answer is it's not on my balance sheet. So, if I married Buffy the cocktail waitress, and surprise, surprise, this long marriage of 6 months comes to an end, and I get divorced, none of the assets in my former wife's trust are mine. So it is impossible for them to become marital property and subject to any fights in the divorce court. It has also become clear to me as my daughters get older that I will not be able to choose their spouses. I know it's horrible, but that's the way it is. One thing I can do is make sure that whoever my daughters choose to marry never becomes a beneficiary of their inheritance. The reason is that when you set up your revocable trust and you put your stuff into your wagon, when you pass away, that stuff is to benefit someone other than you. So when my wife passed away, her revocable trust became irrevocable, meaning that she is no longer able to change the instruction manual. So when someone passes away, you read the instruction manual and that tells you what to do. That instruction manual might say, if Chris marries Buffy the cocktail waitress, he's no longer a trustee. The instruction manual may say, if one of my children passed away, then it goes to my grandchildren. You can have bloodline protection. You might say, as some of my clients have, when my child passes away, I want 1/2 to continue to benefit their spouse. But if that spouse remarries or passes away, then it goes to my grandkids. There's all types of options. And that's part of the benefit of meeting with an experienced wealth planning attorney, because they can help you learn all those options so that your goals and your family protections can be achieved. Some of my clients want to set up an irrevocable trust right now, and that makes sense with some of the goals that they have for themselves as well as their family. Sometimes those goals are to reduce federal estate tax. Sometimes it's just to achieve some measure of asset protection for their family. Most prevalent, though, is they're concerned about what happens if they don't die, but they become mentally incapacitated for a long period of time and may have to spend a long period of time in a nursing home facility. If that occurs to them, then their family may lose all of their life savings and their home eventually to the nursing home or to Medicaid. Irrevocable trust planning can provide 2 major roadblocks to Medicaid or the nursing home getting to your home or to your life savings. The first roadblock is that you have a trustee that is different than you. This trustee, although it's not you, could be someone in your family, like your son or your daughter. The other major roadblock is that you limit your access to the irrevocable trust. You may limit your access to merely income, so that the only thing you own is the right to receive income from the trust, and that would be the only part that a creditor could get access to. For example, if you transferred farmland or certificates of deposit or stock to this irrevocable trust, you would still be allowed to receive rent or interest or dividends. However, you would not be able to tell the trustee to sell some stock and give the proceeds to yourself. If you were allowed to do that, guess what a creditor or Medicaid would say to do? Hey, go get the proceeds and pay your own bill. So many of our clients have transferred their home to a trust like this, and maybe they have a nest egg or a rainy day fund, and they transfer that across the fence to this asset protection trust. and they still get the dividends, they still get the interest, and they still retain the right to live in their home. Some of our clients feel if they don't move their home and their nest egg across the fence to this asset protection trust, then they're merely safeguarding their life savings and their home for the nursing home. Now, although this is an irrevocable trust, there are some safeguards. Although this is an irrevocable trust, you may reserve the right to hire and fire the trustee. So if you do need some of the proceeds from, say, stock or CD, you may ask the trustee to distribute that to your children, and then it is no longer in the trust. The children are free to gift that back to you for your use. The next safeguard is you may reserve the right to change who those beneficiaries are. So if they choose not to gift you the proceeds from the sale of that stock, you may change them, and so that will be the last time they are a beneficiary of your trust. Thirdly, you may revoke an irrevocable trust. Now you may say, well, that sounds kind of odd. Well, it is odd. There are numerous ways to do that, and if that applies to you, we can explain it. These are some of the wealth planning options available to you. What's right for you will depend entirely upon you and what's right for your family. I thank you for watching, and I hope to see you in my office soon for a free private consultation.